Good afternoon. My name is Kim Stanger, and welcome to our presentation today. This is the fourth program we're doing in a series of federal fraud and abuse laws and how they might affect your practice or your facility. We talked about ECRA, we talked about an overview of the laws that apply, and then last time we talked a little bit about arrangements with Medicare and Medicaid beneficiaries and patients that could get you in trouble with federal fraud and abuse laws. Today we're going to be talking about arrangements with referring providers. My name is Kim Stanger. I'm the chairman of the firm's health law group, and we like to provide these as a service to our friends and our clients, and hopefully you get a little bit out of it. As far as the things that we're going to talk about today, I'm going to go over briefly the key federal fraud and abuse laws and talk a little bit about some common state laws. And then I'm going to spend most of the time applying those statutes to common situations. A lot of them deal with contracts that you might have with providers. And then we'll also talk about maybe some non-contractual arrangements that you may have with providers and how those federal fraud and abuse laws work into effect there. As far as the written materials, you should have received a link to the PowerPoint slides. Also, we've given you a copy of the OIG's Supplemental Compliance Program guidance that summarizes these laws and applies them at least in the hospital context. We've also given you a copy of the OIG's guidance for physician practices dealing with fraud and abuse issues. And we've given you some, I think, other articles, or we have a bunch of other articles dealing with fraud and abuse issues that are available for free on our website, should you like to receive them. If you didn't get that link, please contact Laura at the email below, and she'll make sure that she gets those to you. Next, as we go along, you may have questions. Rather than take those questions on the call, which is recorded, by the way, we thought that we would go ahead and ask you to submit those via the chat feature or shoot me an email, and I will go ahead and respond to those as I'm able after the program. For those of you who submitted questions over the last couple of programs, I apologize. I've been swamped and I haven't got to those, but I'll try to get to those this weekend and get right back to you. With that, final disclaimer. Remember that this is an overview of the relevant laws. A lot of these laws are very complex. We'll talk about some of the safe harbors. Those safe harbors have a lot of different provisions and conditions that have to be satisfied. So if you think that one of those may apply, you really need to crack the books and take a look at the specific application to your situation. Look at the specific requirements. Also remember that I'm only going to talk about certain laws. These are the most common ones dealing with healthcare transactions with referring providers, but there may be other laws, especially state laws. Because we've got people from all around the nation on the call, we're really only focusing on federal laws today, although I'll highlight maybe some of the potential state laws that may apply in your state. Just make sure that you remember that when it comes time to apply this, that you check for other laws, including those laws in your particular state. Finally, the applications of the law may vary depending upon the circumstances. For example, the parties who are involved or the nature of the relationships. For example, STARK only applies to physicians. If you're now dealing with physicians or members of the physician's family, you generally don't have to worry too much about STARK, but you would under the Anti-Kickback Statute. If there's a question, make sure you check with your compliance professionals or qualified attorneys when it comes to actually applying these things. Now, with that said, let's talk briefly about the fraud and abuse laws that normally come into play. The first is the Federal False Claims Act. That states that you can unknowingly submit a false claim for payment to the federal government. That has been expanded relatively recently in the healthcare context to include not only claims that are submitted that you have incorrect information, but if you submit the claim with knowledge or that claim does not comply with certain federal regulations governing payment for those claims, then that can also be a false claim. That was recognized in the Supreme Court case, the Escobar case, under the implied certification theory. The theory there is when you submit the claim, you are certifying to the government that you have satisfied all the conditions that are associated with payment for that claim. So if, for example, you violate the STARK law or the Anti-Kickback Statute, you have not satisfied the relevant requirements, and therefore when you're submitting that claim, you're submitting it in violation of those statutes. That constitutes a violation of the False Claims Act, which could subject you to penalties. Perhaps most importantly, you have an affirmative obligation in the wake of the Affordable Care Act to report and repay any overpayments that you receive. Those overpayments include payments that you've received that you shouldn't have gotten because you didn't comply with STARK or the Anti-Kickback Statute, the Civil Monetary Penalties Law, or other statutes. In addition to having to do that repayment, you can get hit up with civil monetary penalties of anywhere from close to $12,000 to about $22,000 per claim. Now, that's not per mistake. That's each time you submitted that claim to the government that's improper, you can get hit up with a separate penalty for each one of those claims. You can also get hit up with treble damages and be excluded from Medicare and Medicaid, and you can be subject to a qui tam lawsuit. A qui tam lawsuit is where a private individual goes out and sues you on behalf of the government, and then if they're able to recover through the litigation or settlement, then they get a portion of or percentage of that recovery. So they effectively become bounty hunters. So you not only have to worry about the government coming after you if you're violating these fraud and abuse laws, you have to worry about competitors or disgruntled employees or others who can file these qui tam actions against you. Next one is the Anti-Kickback Statute. The Anti-Kickback Statute is very broad. It says you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by federal health care programs unless you structure the transaction to fit within a regulatory safe harbor. So the government doesn't want you going out and giving kickbacks or incentives for beneficiaries or other providers to refer Medicare or Medicaid business to you. If you do, you need to make sure that you've structured that deal to fit within a regulatory safe harbor, or you face significant penalties. Unlike the False Claims Act, the Anti-Kickback Statute is a felony. You go to jail for this one, up to 10 years in prison. They increase the fines now up to a $100,000 criminal penalty. You can get hit up with a $100,000 civil penalty plus treble damages. And it's automatic exclusion from the Medicare and Medicaid program. In addition, in the wake of the Affordable Care Act, a violation of the Anti-Kickback Statute is an automatic False Claims Act violation. So you can get hit up with those. In addition to the Anti-Kickback Statute penalties, all of those penalties under the False Claims Act that are listed right there, including being subject to a qui tam action and getting hit up with those, having the obligation to do the affirmative report and repayment. Now, a couple of things about the Anti-Kickback Statute. It is very broad. It applies to anyone who offers, pays, solicits, or receives the remuneration. Now, that applies to both sides of the transaction. So if you've got a referring provider who comes to you and says, hey, tell you what, you give me X dollars, I'll make these referrals over to you. Well, in that situation, that would apply to the physician as well as the party who's actually paying for that remuneration. Next point, it applies to any remuneration, which is incredibly broad. It's anything of value. Could be free or discounted items or services. It could be payments above or below fair market value. It could be gifts, perks, investment opportunities, whatever is of value. Anything of value could trigger the Anti-Kickback Statute. Now, note that the Anti-Kickback Statute only applies to these referral arrangements that involve federal health care programs, including Medicare, Medicaid, or other federal health care programs. If you are going to engage in purely private pay situations, you may not have a problem under the Anti-Kickback Statute, but you could have problems under state laws. In addition, some people say, well, okay, we can get around this. What we're going to do is offer kickbacks for the referrals for private pay business, but not for Medicare and Medicaid business. The government is wary of such carve-out arrangements because they realize that if you're going to pay kickbacks in order to get private pay business, but that provider is also serving their Medicare and Medicaid business, then those payments really incentivize the referrals for Medicare and Medicaid also, so you're not necessarily safe. Now, note that the Anti-Kickback Statute is an intent-based statute. You have to have improper intent, but that's only intent to offer induced referral. It doesn't mean that you don't have to have intent to violate the law. Ignorance of the law is no excuse. In addition, in determining intent, the government applies what's called the one-purpose test. That means if one purpose is to generate improper or reward improper referrals, it doesn't matter if you've got 99 legitimate reasons. If one purpose is to induce improper referrals, then in that situation it's a violation of the Anti-Kickback Statute unless you've structured the deal to fit within a regulatory safe harbor. A new statute that recently came out this year in the wake of the opioid epidemic is the Eliminated Kickback and Recovery Act. It's similar to the Anti-Kickback Statute, except in some ways it's narrower and in some ways it's broader. It's narrower in that it only applies to these remuneration relationships that are involving referring a patient for laboratory recovery homes or clinical treatment facilities. So Anti-Kickback Statute applies to any government programs. The Eliminating Kickback and Recovery Act only applies to these referral arrangements where you're soliciting referrals for laboratory services. It's broader than the Anti-Kickback Statute in that the Anti-Kickback Statute only applies to referrals for items or services payable by federal healthcare programs. ECRA applies to any payer, including private payers. So if you've got these kinds of referral relationships with private payers, labs have these referral relationships or services arrangements for these referrals for laboratory services, you need to really be concerned about the ECRA. Now, what are the penalties? Well, again, this is a criminal statute, up to $200,000 criminal fine and 10 years in prison. If you've got an ECRA violation, there's a good chance that you may have an Anti-Kickback Statute violation. A lot of the safe harbors that apply to anti-kickback violations don't exist, at least currently, under ECRA. ECRA does have some safe harbors, but they're much more narrow than the anti-kickback safe harbors. We're expecting regulations concerning ECRA, but we haven't got those yet. So in the meantime, everybody's kind of scratching their head thinking, okay, how's the government really going to enforce this? What are going to be their standards? Are there going to be safe harbors? The bottom line is, if you're doing deals involving referrals for laboratory, recovery home, or clinical treatment services, you better darn well be careful when it comes to ECRA. All right, next statute that applies whenever you're dealing with physicians or members of a physician family is the Federal Ethics and Patient Referrals Act, or more commonly known as the Stark Act. Stark says that if a physician or a member of the physician's family has a financial relationship with another entity, that physician may not refer patients to that other entity with which they have a financial relationship for certain designated health services that are payable by Medicare or Medicaid unless they've structured the deal to fit within the safe harbor. And if that physician does make an improper referral, that entity may not bill Medicare or Medicaid for that service, again, unless the arrangement was structured to fit within a regulatory safe harbor. What are the penalties? Well, this is a civil statute, so you don't necessarily go to jail, but at the very least, you can't bill the government for those services. And if you bill them improperly, then you've got to do a repayment within 60 days. If you fail to repay within 60 days, you can get hit up with a civil penalty of $25,000 per claim submitted. In addition, if you're a physician trying to come up with a circumvention scheme, you can get hit up with additional penalties of $165,000 per scheme. If you've got a Stark violation, there's a good chance you've got an anti-kickback violation, and you will also have a False Claims Act violation because you submitted those claims to the government under certifying that you're in compliance with relevant laws, and if you didn't comply with Stark, you shouldn't have been submitting the claims to the government, and therefore there's a False Claims Act violation. Now, a couple of comments concerning Stark. Stark only applies to financial relationships with physicians or a member of the physician's family. It does not apply to everybody. So when we're talking about the deals today, if we're talking about deals or arrangements with physicians or a member of the physician's family, you got to be concerned about Stark. If there's no physicians involved, you don't have to worry about Stark, but you may have to worry about the Anti-Kickback Statute or other state laws that might apply in those situations. All right, the next one we have to worry about is the Civil Monetary Penalties Law. As we talked about last time, Civil Monetary Penalties Law is this law that's kind of a catch-all, and it prohibits a bunch of different types of different conduct. We talked about some of those relevant to Medicare and Medicaid beneficiaries last time, but for purposes of today, you need to know that, among other things, the Civil Monetary Penalties Law prohibits hospitals or critical access hospitals from knowingly making a payment directly or indirectly to a physician as an inducement to reduce or limit medically necessary services that are provided to Medicare or Medicaid beneficiaries who are under the direct care of the physician. So it helps to kind of put this back in context to understand where this law came from. When the government changed to a DRG system where you're paid, changed to the prospective payment system, so hospitals were no longer being paid based on fee-for-service, but instead they were going to get one payment for this episode of care, for this diagnosis, and then it's up to the hospital to provide services within the payment that they receive from Medicare. If the hospital does, it makes money. If the hospital doesn't, then the hospital loses money. Well, the government realized, well, that creates an incentive for the hospital to reduce services, thereby reducing its costs. And the government was afraid that the hospital may go to the physicians and say, hey, you help us reduce costs, help us reduce these services to the patient, don't order so much stuff, and then we'll share those profits with you. That's what this civil monetary penalties law provision was designed to protect against. Now, some of you may be scratching your heads and thinking, well, isn't that the Medicare Shared Savings Program? Isn't that an ACO? Isn't that what we're trying to do, is share those savings? The answer to that is, well, yes, but in order to do that, there's a carve-out under the the civil monetary penalties law and anti-kickback statutes that apply to participation in those ACO programs if you satisfy certain requirements. But outside of the Medicare Shared Savings Program, you got to be careful about these types of gain-sharing arrangements. We'll talk about that more in a little bit. What are the penalties for a violation of this particular provision in the civil monetary penalties law? Well, it's $5,000 per violation. You can also be excluded from Medicare or Medicaid. There's a good chance you may also have a Stark Law problem and potentially an anti-kickback problem if you engage in those types of arrangements. Next one, under the civil monetary penalties law, are the penalties that are associated with being an excluded entity. Basically, once you're excluded from participating in the Medicare or Medicaid program, it's kind of a death knell for you ever getting involved in that program in the future or providing many services in the healthcare industry. Under the civil monetary penalties law, it says that an excluded person that's been excluded from participating in Medicare or Medicaid, cannot order or prescribe an item or services payable by the federal health care program. If they do, an entity can't submit that claim for an item or services that was ordered or furnished by an excluded person. If you are an owner of an entity that participates in federal programs and you've been excluded, you can no longer have that ownership interest. And you cannot, if a person has been excluded from participating in Medicare or Medicaid, they can't be hired by a participating entity to provide items or services that are payable by federal health care programs. So, for example, you want to hire somebody, unbeknownst to you, that person was excluded from Medicare or Medicaid, you put them in maybe an HR role. If any of the money for Medicare or Medicaid is finding its way into that person's pocket because of salary or compensation or somehow, then that would violate this excluded provider or this exclusion provision. What are the penalties? Well, it depends on the type of situation, but if it's a situation where you have improperly submitted a claim to the government, you can get hit up with a penalty of $20,000 per item or service that was ordered. If it's a situation where you are an owner when you shouldn't be, you can get hit up with a penalty of $10,000 per day. That prohibited relationship exists. You can get hit up with treble damages, a repayment of the amounts that's been paid, and you yourself can be excluded from Medicare or Medicaid just along with that provider or employee that you hired that were excluded. Bottom line is you need to make sure that you check your list of excluded individuals and entities, that list that the government publishes, to make sure that you're not providing services that were ordered by an excluded provider, or that you're not contracting with or hiring an excluded entity. Otherwise, you may have problems. All right, those are the main federal statutes. Remember that there may also be state statutes. Most statutes have their own version of the anti-kickback statute. Usually those are limited to like Medicaid program payments, but in some states they can be expanded to some of those anti-kickback statutes apply to private pay situations. A lot of states have their own versions of Stark, a mini Stark law they're commonly called. So you need to know about those self-referral relationships or statutes in your particular state. You got to be concerned about licensing statutes and Medical Practices Act. Usually they will have provisions in there that prohibit paying for referrals or fee splitting or things like that. So make sure that you check those statutes. You got to be concerned about your Medicaid statutes, regulations, and provider agreements because they may also impose penalties, limits on certain types of transactions. When it comes to those state laws, again, be careful because they may be broader than the federal statutes. They may not be limited to just government payment programs. You also should be aware of what's in your payer contracts. Some payers are starting to put in some provisions that invoke some of these fraud and abuse concepts, and including things like waiving copays and deductibles, offering kickbacks in order to get referrals, and those types of things. Okay, that's a general overview of the rules. Let's talk now about applying those to situations. First and foremost, let's talk about what you do when you want to contract with a referring provider. It could be an employment relationship, an independent contractor relationship. Maybe they're part of your group. Maybe you want to do a lease, a recruitment agreement, or any other contract that you're doing with a referring provider. If you and or the physician are engaged in Medicare or Medicaid or other government health care programs, you generally have to be concerned about Stark and the Anti-Kickback Statute. Even if there aren't going to be any referrals for government programs, you may still need to be aware of your state laws because, again, they may be broader and they apply to private payer situations. Let's talk first about employment situations. Well, if you're going to employ a physician, presumably they're going to make referrals to you. If those referrals are going to involve services that are payable by federal health care programs, you got to be concerned about the Anti-Kickback Statute and potentially Stark. Now, when it comes to employment contracts, it's relatively easy to satisfy these requirements. Under the Anti-Kickback Statute, they have an exception that applies to bona fide employment relationships. Generally, as long as you're paying the employee or this referring provider as an employee, you're probably going to be safe. In fact, you could probably even pay them under the Anti-Kickback Statute based on referrals. There is old commentary from the OIG which suggested that they may look at situations if you're paying physicians or referring providers or other employees based on their referrals, because in that situation, you're not paying them to provide services that are payable by the program. Instead, you're paying them for these referrals, that could create a problem. More recent commentary, though, seems to suggest that as long as you're employing these guys, you've got a lot of leeway in how you structure the deal. In Stark, it's a little bit more limited. If you're dealing with physicians or members of the physician family, you need to make sure that that employment contract satisfies certain requirements. In general, that means that it has to be consistent with fair market value for the services that they provide. That compensation arrangement cannot take into account the volume or value of referrals for designated health services that they make, for those referrals that are provided through your facility or group. Now, that limitation does not apply to services the physician personally performs. You can always pay the physician based on the services they personally perform, whether that's per patient visit or per hour or per work RVU, something like that. As long as you're paying them based on the services they personally perform, you're generally okay. But you can't pay them based on their referrals for ancillary or other services if you want to fit within the Stark employment safe harbor. In addition, the overall contract has to be commercially reasonable, even if there were no referrals made. So it's not like you hire this person as a sham employee. You really don't need their services. And by the way, they're really not doing anything, but you're just going ahead and you're paying them anyway because you want their referrals. Now that wouldn't work because the overall arrangement has to be commercially reasonable. Note that for an employment contract, to satisfy Stark of the Anti-Kickback Statute, it doesn't have to be written. The compensation structure doesn't have to be set in advance. You can change the compensation at any time. You have a lot more flexibility as long as you are hiring them as a bona fide employee. You just need to generally make sure you're paying them fair market value, that fair market value doesn't vary with the volume or value of referrals if they're an employee or a member of the employee, if they're a physician or a member of the physician's family, and that it's a commercially reasonable transaction. Now, in contrast, if you're going to hire that person as an independent contractor, the rules are a little bit different. These could be your professional services agreements that aren't employment. It could be call coverage arrangements with non-employees. Could be medical directorships. Maybe you're paying medical staff leadership some amount and they're not employees. Could be you're paying somebody to provide supervision for advanced practice professionals or the like. Maybe you're paying somebody to provide management services or administrative services or any other situation where you're paying these referring providers to provide services when they are not employees. Well, you're generally going to want to make sure that you're complying with the federal fraud and abuse laws if they're going to be making referrals for any items or services payable by federal health care programs. If you're dealing with a physician or a member of the physician's family, the requirements are much more prescriptive than they were for employees. You have to have a written agreement that specifies the compensation and the services that are provided. Under employment, you don't have to have it in writing, but under Stark, you do. Now, a couple of years ago, the CMS came out and modified this a little bit. It doesn't have to be a formal agreement. It doesn't have to be a formal contract. You can manifest that writing by a series of documents, maybe emails or other things, as long as it's got the price, terms, and the like, and it's signed by the parties and specifies the terms. But there has to be something in writing that's signed by the parties. In addition, the compensation formula that you're paying has to be set in advance. So you can't just figure out what they're worth after the fact, and you can't change the compensation as you're going along. The compensation structure has to be set in advance, and it has to be objectively verifiable. Now, unlike the Anti-Kickback Statute to satisfy Stark, the aggregate compensation doesn't have to be set in advance, but the compensation formula has to be set in advance. That compensation has to be consistent with fair market value, and it can't take into account the volume or value of services or other businesses generated by the physician. Now, note a difference between the Stark law for independent contractors and employees. For employees, note that to satisfy Stark, the Stark safe harbor for employment, the compensation can't take into account the volume or value of referrals for designated health services. So theoretically, you can comply with Stark by paying that physician based on referrals for non-Medicare or Medicaid business or non-DHS services. When it comes to independent contractors, however, it's more restricted. You can't pay that independent contractor in a manner that would take into account the volume or value of designated health services or other business, even private pay business, that's generated by the physician. In addition, the arrangement has to be commercially reasonable and further a legitimate business purpose. So you're not just doing this as a sham, as a way to funnel money in order to get referrals from this guy. And the compensation can't be changed within a year. Technically, the safe harbors basically say that the contract cannot be for less than a year. Actually, you could have a contract that you terminate before the year, but if you do terminate it before the year, you can't enter into a new contract with different terms within that original one-year period. The key here is the government's concerned about entering into a series of very short-term contracts where you're modifying the compensation structure based on referral patterns. So to prohibit that, they say, okay, fine, you can enter into the agreement, but the agreement has to be for at least a year. You can't change those compensation terms within that one-year period. Now, that's to satisfy Stark. Those are the requirements you're going to have to look at if you're doing a deal with a physician or a member of the physician's family on an independent contractor basis, like your medical directorships, professional services arrangements, and so forth. Well, in addition, to Stark, you always have to worry about the Anti-Kickback Statute. The Anti-Kickback Statute is broader. Again, it would apply not only to physicians, but advanced practice professionals or anybody else you're going to hire. You have to comply with the Anti-Kickback Safe Harbor for independent contractor relationships. You have to have a writing that's signed by the parties and specifies the services that are going to be provided. The aggregate compensation has to be set in advance. Note here that under the Stark, it's just the compensation formula has to be set in advance. To satisfy the Anti-Kickback Statute, the aggregate compensation that you're paying actually has to be set in advance. So you cannot comply with the Anti-Kickback Safe Harbor and pay like per service or per hour, because in those situations, the aggregate compensation is not going to be set in advance. Now, you still may not violate the Anti-Kickback Statute, it's just we won't fit within the safe harbor. In addition to comply with the Anti-Kickback Statute safe harbor, the compensation cannot take into account the volume and value of referrals for federal program business, and the aggregate services cannot exceed those that are reasonably necessary to accomplish a commercially reasonable business. bottom line here is anytime you're paying a non-employed provider to provide services, you need to make sure that you look at their deal and you structure it to fit within these safe harbors. And monitor that as you go along, because you could have problems where suddenly you find out after the fact that they really weren't providing the services that you were paying them for, or that you were overpaying them for the services provided, or something like that. So you need to periodically review and monitor the compliance. All right, a word here about requiring referrals. A lot of people think that you cannot require these contracted physicians or providers to make referrals to you. So, for example, if you're a hospital, a lot of people think, well, you can't require those employed physicians to make referrals back to the hospital. That is actually not the case under STARK. STARK will allow you to require referrals. Technically, under the special rules on compensation in 42 CFR 401.354D4, they state that an employer can, or a person who contracts with somebody to provide services, can condition their compensation on the referrals if you satisfy certain requirements. One is that requirement for those referrals has to be set forth in the contract. The compensation has to be fair market value and can't take into account the volume or value of the referrals otherwise. And the referrals have to relate solely to the physician services under the contract, and they have to be necessary to effectuate the intent of the contract. The example that I give there is, for example, let's say you hire a physician to provide services at your hospital on a part-time basis. You can require the physician to make referrals to you for the services that they're providing or related to the services they're providing while they're part-time for you, but you can't also require them to make referrals to you for the services when they're on their own time outside the scope of the agreement. In addition to those requirements, you have to build in an exception, so you can't require referrals if the patient prefers to go to a different provider, or if the insurer determines which provider renders the services, or if the physician determines that the referral to the required provider is not in the patient's best medical interest. Then in those situations, you can't require referrals for those situations. Now, this is a provision under STARK. There is not a similar provision under the Anti-Kickback Statute, and sometimes people wonder, well, if you place one of those referral requirements in a contract, it may be okay under STARK. Is it going to violate the Anti-Kickback Statute? I think you'll probably be okay, but I have not seen any guidance from the anti-kickback authorities on those issues. All right, let's talk about group practice arrangements. Let's say you're not a hospital, you don't employ the physicians or things like that, but you've got your own group practice. Do you have to worry about these things? Yeah. Well, are you paying the physician for referrals? Well, you're paying them, and if you're paying them in order to get referrals, then that is going to trigger the Anti-Kickback Statute if you're doing items or services that are payable by federal health care programs. In addition, if that physician or a member of the physician's family is going to be making referrals to others within the group for certain designated health services payable by Medicare or Medicaid, you've also got to be concerned about STARK. So STARK and the Anti-Kickback Statute apply even to your own physician group and referrals that are made back and forth within a physician group. Now, there are exceptions that potentially apply. Most importantly, STARK has what are called the group practice exceptions, that if you qualify as a group practice, then there are certain exceptions that would allow you to make these referrals back and forth. We'll talk about that in just a minute. In addition, if you're an owner of the group practice or another entity, then there's exceptions that apply to rural providers or the whole hospital. If you're non-owners, so you're just employing a physician in a group or contracting with a physician, but they're not an owner, then you could structure the deal to fit within one of these group practice exceptions under STARK, or you could structure the deal to fit within an employment or personal services exception. You only need one exception. Those are some of the available exceptions. All right, let's talk a little bit further about this. If you're going to rely on these group practice exceptions, including the physician services or in-office ancillary services exception that would allow the physicians to make referrals back and forth within the group to others within the group or for ancillary services within the group, then in order to qualify for that, the group has to qualify as a group practice. It has to fit the definition under STARK for a group practice. That definition is set out in 42 CFR 411.352. There's a bunch of requirements that have to be met in order to qualify as a group practice. Among others, the overhead expenses and income distributed for the group has to be distributed per a method that is determined before receipt of payment for services. So you're developing the compensation plan and you have it applied prospectively. And the physician's compensation may not be based on the volume or value of the physician's referrals for designated health services, except that there are special rules regarding productivity bonuses or profit shares. Now, most group practices of which I know are on an eat what you kill type model. And they assume that they can pay the physician if the physician orders the lab test, then the physician gets credit for that lab test and they get more compensation for ordering that lab test. Well, that potentially violates the Stark requirements, because at that point the compensation structure is going to vary with the volume or value of referrals from that physician if those are referrals for designated health services. And unless they've structured the deal to fit within certain safe harbors, then you could have problems with that group compensation arrangement. Let's talk about a couple of those special safe harbors that apply to group practice compensation arrangements. Well, the definition of a group practice under Stark says that you may pay the group physician based on services the physician personally performs or incident to services that are billed incident to that physician's services. So you can always pay them based on what they're personally doing or their incident to services. You can also pay a productivity formula that's deemed, under the safe harbors, a productivity formula is deemed not to be based on referrals, so not to violate Stark. If, for example, it's based on the total patient encounters or work RVUs, so it's really based on the services that they perform. It's based on the allocation of compensation attributable to services that are not DHS payable by federal program or private payers, so you come up with some method that's not linked to, not based on referrals for DHS, or the revenues from designated health services, DHS, for the group are less than 5% of the total revenues, and the allocated portion of those DHS revenues are 5% of the physician's total compensation. The net effect there is that the revenue from the group and the physician is related to DHS is so small that it really doesn't affect the staff. That's kind of hard to satisfy. The bottom line here is if you're going to pay based on productivity, the general rule is you've got to pay based on the services that physician personally performs or their incident to services. You can't pay them based on services that are performed by others, including services that physician refers to others. Now, there's a second exception that applies to sharing of profits. So let's say in your group you want to give the group members a share of profits. Well, Stark says that you can pay the group physician based on the share of overall profits from designated health services of the group. So you can always give them a per capita, share of the overall profits, not based on simply what they did, but the overall profits of that group. Or you could also break down the group into components, as long as there's at least 5 physicians in that component. So you could have like a pot of at least 5 physicians, and those 5 physicians share in the profits for those 5 physicians. But if you're going to use one of these groups, these subgroups, there's got to be at least 5 physicians in that group. If there's less than 5, then you wouldn't fit within this share profits exception. You may have a Stark issue. There are certain other exceptions that are similar to the productivity base. If, for example, DHS is such a low volume of what you're doing, then you may be able to fit within those safe harbors. The key there is, if you're a physician group, you need to go back and look at your group compensation arrangement and make sure that it's structured to comply with these Stark requirements if there's any referrals within the group for any ancillary services or other services that are payable by federal healthcare programs and that are designated health services under Stark. All right. Stark does have Stark would apply, and potentially anti-kickback statute, to situations where, let's say you as a physician, you want to open up a separate PT clinic or a separate imaging center. Can you make referrals over there? Well, you have a financial relationship. You've got an ownership interest in that other entity. Stark generally says you can't make referrals over to that entity for certain designated health services unless you've structured that transaction to fit within a safe harbor. There are a couple of safe harbors that apply to those ownership arrangements, the most important of which is the rural provider exception. So if you have an ownership interest in an entity that operates in a rural area, which is outside a metropolitan statistical area, then generally you can have an ownership interest in that other entity in that rural area, and you can make referrals over there, and you don't need to worry about the group practice exceptions if you are an owner. In addition, Stark also has a separate safe harbor for ownership in the whole hospital. This is the exception that physicians would rely on when they were, building specialty hospitals years ago. That as long as they have an ownership interest in the whole hospital, not just a department of an existing hospital or a part of an existing hospital, but an ownership interest in the whole hospital, then Stark would allow it. A few years ago, they started ratcheting back so that they've now limited a physician's ability to have that ownership interest in the whole hospital. They grandfathered ownerships that existed prior to 2010, but as of 2010, they limited the ability of physicians to engage in this safe harbor going forward. In addition, there's some additional requirements that have to be satisfied if you've got an ownership interest in a specialty hospital, things like notices and reports and certain things like that. So just be aware of those requirements. Well, what about ASCs? A lot of physicians have ownership interests in ASCs. How are they doing those? Well, if it's in a rural area, then I guess they don't need to worry about Stark because they can fit within the rural provider exception. Aside from that, though, most people get around Stark in the context of ownership interest in ASCs because Stark only applies to referrals for designated health services, and designated health services are defined to exclude services that are payable by a composite rate, like ASC services. Because ASC services are generally paid by a composite rate, they do not constitute DHS, and therefore the physician is not making referrals to that ASC for designated health services. So Stark generally doesn't apply to a physician's ownership in an ASC. It might if that ASC is providing services that are not paid by that composite rate, and that physician with an ownership interest is making referrals to the ASC for that stuff, but that's usually not the way ASCs are structured. Now, you still have to be concerned about the Anti-Kickback Statute. Well, the Anti-Kickback Statute has safe harbors that apply to ownership of ASCs. It depends on the type of ASC, whether it's a surgeon-owned ASC, a single specialty ASC, multi-specialty ASC, or a hospital physician ASC. For each one of those different types, there's certain requirements that have to be satisfied. If you satisfy all those requirements, then you fit within the safe harbor, and that physician can have an ownership interest in that ASC and make referrals over. You just want to make sure that that ASC is structured in order to fit within that safe harbor or feel relatively comfortable that you otherwise aren't going to have a violation of the Anti-Kickback Statute. All right, let's talk about recruiting providers real quickly. What about if you want to recruit somebody into your facility, into your hospital? Well, that's going to create a financial relationship. There's going to be incentives. You're probably going to want referrals from that provider. That's your whole purpose for recruiting them, right? Well, that means that you need to structure the arrangement to fit within a Stark or an anti-kickback safe harbor if there's going to be any referrals for government programs. Now, potentially applicable safe harbors, well, you could set it up as an employment arrangement if you're going to recruit an employee or an independent contractor. Could be a group practice safe harbor if you're recruiting into a group, if you're a group practice and recruiting somebody. But in all of those first three, the compensation you pay that physician is going to be limited to fair market value because that's pretty much, well, except for the group practice, but of the first two, the employee safe harbor and the independent contractor, you'd have to pay him fair market value. What about if you need to pay him more than fair market value in order to get him to come to your area? Well, Stark and the Anti-Kickback Statute both have safe harbors that will apply if you want to recruit somebody into your area, but they only apply to certain types of entities. They allow hospitals or FQHCs to pay more than fair market value to recruit a physician, or, in the wake of a recent amendment under Stark, advanced practice professionals, to recruit them into the service area. Let's talk about some of those conditions. For Stark, it covers the payments by the hospital to recruit the physician. You've got to have a written recruitment agreement. That physician generally has to relocate from 25 miles outside that area into the area. They can't otherwise be a member of the medical staff, so they can't, prior to the recruitment agreement, can't have medical staff privileges at the facility. The whole recruitment incentive is to get them to come. It doesn't work if they're already there. There are certain exceptions for that relocation if, for example, they are finishing up a residency or they are employed by the federal government as by the VA or something like that, but that doesn't apply too much. That recruitment arrangement can't generally be based on referrals. If they're going to recruit into an existing physician group, then there's certain additional requirements that have to satisfy. So let's say a hospital is going to subsidize the recruitment efforts to get a physician to come and join a separate group. In that situation, that written agreement has to be signed by the hospital, by the physician who's being recruited, and also the group. In addition, the hospital is limited in the amount that it can pay. Generally, the hospital, if there's going to be an income guarantee, they can only pay the additional incremental expenses that are associated with bringing that physician into that group. They can't pay above and beyond that to essentially subsidize or provide subsidies that are going to benefit the other members of the group. There are certain other limitations and conditions that have to be satisfied. Make sure you're familiar with those limitations if you're doing recruitment agreements. A couple of years ago, they amended Stark to extend recruitment assistance that, for example, a hospital provides to a physician group to recruit in mid-level or advanced practice professional. There are additional requirements that have to be satisfied for those types of arrangements. They're different than the requirements for the physicians. Just make sure if you're going to recruit in mid-levels or advanced practice professionals that you check the safe harbor for those. Now, that's Stark. What about the anti-kickback statute? Well, you got to be concerned about the anti-kickback statute. In addition to Stark, if there's going to be any referrals from that recruited provider for items or services payable by federal health care programs, among other things, the anti-kickback statute only applies to induce practitioners to come into a HPSA. So it's not all practitioners, but only those who are going to come into a HPSA. And so it's going to have to, by definition, generally be primary care providers. There has to be a written agreement. 75% of the revenues have to come from the new practice, not from someplace else. The terms of the benefits generally can only be provided for up to 3 years. You can't renegotiate those terms within 3 years. You can't require referrals. You can't restrict their ability to have staff privileges elsewhere, at, for example, another hospital. You've got to require that they do not discriminate against federal program beneficiaries. They're going to have to take Medicare, Medicaid, and the like. And you can't, under the anti-kickback statute, that recruitment safe harbor can't benefit any other person. So to fit within the anti-kickback statute, you couldn't recruit into an existing practice because that would benefit the existing practice. So even though it would satisfy Stark, it wouldn't fit within the anti-kickback safe harbor, so you'd want to make sure you build in additional protections and consider the potential anti-kickback implications before you do the joint recruitment agreement. There are also special safe harbors under Stark if you want to make retention payments to a non-employee. It would allow you to do so if certain conditions are satisfied. In the interest of time, I'm not going to go through those. What about if you want to lease space or equipment or allow a physician or another referring provider to use space at your facility? Maybe it's going to be a visiting specialist or a physician in town wants to lease space. Well, you're providing them value, something of value, it's remuneration, so you're going to want to structure your arrangement to fit within, if it's a physician or a member of the physician's family, you want to structure to fit within a Stark safe harbor, or if it's anybody else who's going to make referrals for items or services payable by federal health care programs, you want to make sure that you structure the deal to fit within the anti-kickback statute. Now, both of those have very specific requirements that you're going to need to satisfy. In the interest of time, I'm not going to go through all of those. Just make sure that you structure those appropriately, including the method in which you structure the rent. Well, what about if you're a hospital and you're allowing physicians who are medical staff members to come in and perform surgeries at your facility, but you're not leasing space to them? Are they using your equipment? Are they getting a benefit? Yeah, but you're okay as long as you're billing the technical or facility fee and the physician's billing the pro fee. In those situations, the government recently clarified that you're really not providing remuneration. You're getting paid by the government for the facility and the use of the equipment yourself. The government's paying you as the hospital. As long as the physician's just billing their pro fee, then they're getting paid by the government for the services that they provide, not for use of your stuff, and therefore you're probably going to be fine. Problems can exist, however, if you're allowing a visiting specialist or others to use space or equipment at your facility and that other person is billing globally. So they're getting paid as if they were providing the services in their own office. They're getting assigned a service modifier that indicates that it's their own office. but you're providing the space and you're providing the equipment. In that situation, that does create potential problems under the Stark and the Anti-Kickback Statute, so beware of those situations. Now, among other things, to satisfy the Stark safe harbor, the the physician or the family member who's using the space has to have exclusive use of the space during that period of time, during the lease. Well, that creates problems for like visiting specialists or others. What if they want to come in and they just want to use some of the space but want to share that space with others? If you've got to do this exclusive use, well, that makes these leases kind of problematic, and it costs more money, and it's real problematic in trying to do it. So a couple of years ago, they came out with a new Stark safe harbor that applied to timeshare arrangements, which would basically, if you satisfy the safe harbor, allow a physician or their family member to come in there and basically share space, so it doesn't have to be exclusive. The requirements for the timeshare safe harbor are different than the lease safe harbor. This is a new option and probably more attractive for most of you who have visiting specialist arrangements. You may want to look at this timeshare alternative. I'm not going to go through the requirements in the interest of time. There are other safe harbors that apply to, for example, the isolated transactions or the one-time sale of a practice. You would just want to structure your deals to fit within those. There are safe harbors under the Stark law for indirect financial relationships. So let's say, for example, you are a hospital, a DHS provider. You contract with another entity, to maybe another hospital, to provide those services, and that hospital then employs a physician, and that other hospital provides those services to you through this employed physician. Well, that creates an indirect financial relationship with that referring physician. But under the Stark definitions, as long as that employment contract or that contract between the referring physician and that contracting entity, as long as its compensation, the physician's compensation, doesn't vary with the volume or value of referrals, then that makes it so that there is no financial relationship for purposes that would trigger Stark, and so you can go ahead and enter into those transactions. This occurs sometimes, I've seen it in the context of leases. For example, you may have a situation where you are a local rural hospital, you contract with a large medical center in a metropolitan area to send down their specialists to your area. You allow them to come in and use your space, but maybe you don't have a formal lease with that other entity. Well, in that situation, you would, as long as the financial relationship between the specialist who's coming to visit and their employer, that medical center, as long as their compensation doesn't vary with the volume of value referrals that they're making to you, then that would create an indirect, or that would trigger this indirect financial relationship exception, and therefore Stark would not apply to that particular exception. You'd still have to worry about the Anti-Kickback Statute, but you may be able to avoid Stark penalties in that situation. All right. Okay, so that's kind of as a summary of the contractual relationships you might have. What about if you don't have a contractual relationship, but you just want to provide gifts or other freebies to these potential providers who are providing referrals to you? Maybe you want to send them the gift basket. Maybe you want to give them some kind of thank you or appreciation gift. Maybe you want to give them some kind of a gift hoping that they're going to provide more referrals over to you. Maybe you want to provide them with free items or services. Maybe you want to give them free, you're a hospital and you want to provide free CME or free travel to them, or give them free space or equipment, or subsidized insurance or things like that. Maybe you want to provide them with discounted items or services. You're not going to charge them the full market rate. You're going to charge them a discounted item or services. What about if you're paying them for services not performed, or payments for unnecessary services, or business opportunities, things like that? The bottom line is, anytime you're giving anything of value to these referring providers, again, you've got to be worried about Stark and the Anti-Kickback Statute. For purposes of Stark, anytime you're giving that remuneration, it's going to create a financial relationship that's going to trigger Stark, and therefore if there's going to be any referrals back for designated health services, you need to make sure that whatever you're giving is structured to fit within one of the Stark safe harbors. We'll talk about that more in a minute. Similarly, if there's going to be referrals for items or services payable by federal health care programs, And one purpose of making that gift or giving that freebie or providing that remuneration is to reward or induce those referrals. Then you've got to be concerned about the anti-kickback statute. Now, if there is no federal program referrals involved, then it's probably less risk if it's purely private pay, but you've got to be concerned about your state laws to make sure there's no state laws that would prohibit those types of kickbacks or free remuneration in order to cover those types of referrals. Under Stark, there is a safe harbor that applies to professional courtesy. So maybe you want to provide to these referring providers, you would allow them, their staff members or those other physicians to come to your office, and you're going to give them some kind of a break, some kind of insurance billing, or only billing, or some other kind of that break. Well, Stark does allow for professional courtesies, but in order to do that, you got to satisfy certain criteria. The practice has to have a formal medical staff, so it only applies to practices that have more than one physician. You've got to have a written policy approved in advance, so you can't just do this kind of, it's our informal policy that we don't charge these referring providers. No, you've got to have a written policy approved in advance. It has to be offered to all physicians in the service area regardless of their referral patterns. It can't be offered to government beneficiaries unless there's a showing of financial need, and it can't otherwise violate the Anti-Kickback Statute, meaning the one purpose of that can be to induce referrals. So if you have this professional courtesy policy at your practice or at your hospital, you better darn well make sure that you've structured it to fit within the Stark law. In addition, you need to be aware of the anti-kickback and civil monetary penalties limitations if you're, for example, engaging in insurance-only billing or waiving copays or deductibles. If that's your professional courtesy policy, you've got problems because the civil monetary penalties law generally prohibits waiving copays or deductibles to beneficiaries unless there's a showing of financial need. Similarly, most private insurance companies prohibit you from waiving copays or deductibles to the insureds. If you do, then you may violate the insurance contract, and it may at some point rise up to insurance fraud. That could also violate the anti-kickback statute. So beware of those types of professional courtesy policies. Under Stark, there's a separate safe harbor that applies to non-monetary compensation less than $416 per year. It's actually $300 in the regulations, but it's subject to a cost of living modifier. The last modifier for 2019 is $416. This basically says that hospitals or other entities, Stark doesn't apply to items or services that are not cash or cash equivalents that do not exceed $416 a year, as long as offering this gift, this freebie, is not based on the volume or value of referrals or other business generated between the parties. You're not just offering it to those who are good referral sources. It can't be solicited by the physicians or the physician's practice, so they can't show up at the hospital every year and say, hey, give me my $416 gift. If there is a violation of this, Stark will allow that physician to go ahead and repay the excess amount that they received and not violate Stark. They can do that within, I think it's a certain within a certain period of time. Aside from this, Stark does allow, like a hospital, to have one formal staff event, staff appreciation event annually, but if they're going to give out gifts in conjunction with that, it's got to fit within this non-monetary compensation exception. This is the exception that a lot of facilities like hospitals or other entities might use in order to provide a certain level of non-monetary gifts to their medical staff members. There's a separate safe harbor under Stark that applies to medical staff incidental benefits. This basically is limited to items that are valued less than, the regulation says $25, but it's subject to a cost of living. It has to be less than $35. These items or services can't be cash or cash equivalents. They have to be used on the hospital campus. They have to be offered to all medical staff members in the same specialty, so you don't just select those who are good referral sources. It can't be based on the value of referrals or other business generated between the parties, and it has to be provided while the physician is making rounds or engaged in services benefiting the hospital or patients. So these are things like, providing them free parking stalls or providing them free meals at the cafeteria as long as those meals don't exceed $35, and it's otherwise tied to the services that they're providing at the hospital. Gain sharing programs. As I mentioned earlier, START, the Anti-Kickback Statute, and the Civil Monetary Penalties Law potentially implicates gain sharing programs where the hospital goes to, for example, a hospital goes to a physician and says, hey, help us reduce costs and we'll share those cost savings with you. Unless you've structured it to fit within an approved Medicare Assured Savings Program arrangement, then generally the rule is you can't enter in those. There are potential violations of the Anti-Kickback Statute and STARK and also the Civil Monetary Penalties Law. The Office of Inspector General has approved some of those gain sharing arrangements if certain safe harbors are certain protections are built in. If you're interested in doing those gain sharing arrangements, make sure you look at the ACO safe harbors and or look at those advisory opinions to see whether or not you can structure yours in a way that has been approved in the past. I've covered the main safe harbors. There are some additional safe harbors that apply to things like donations of electronic health record support services and things like that. Make sure that you're aware of those additional safe harbors. Okay, I've covered a lot of stuff today. Bottom line is if you think that you've got a problem based on the things that we've talked about because of some arrangements you've got with referring providers, you need to pay attention to it. Don't simply sweep it under the rug. Remember, under the False Claims Act, you may have an affirmative obligation to report and repay. The bottom line is you may need to don't bill until you get it resolved so that you don't engage in intentional fraud, but you'll want to make sure that you talk with a compliance professional or a qualified counsel to make sure that you address those concerns. Along those lines, our next program in this fraud series is going to be in September 19th, where we're going to be addressing situations where you may have noncompliance. Maybe you do have a noncompliant physician arrangement. What do you do about it? That's what we're going to be talking about next time on responding to noncompliance, self-reporting, and repaying overpayments. We'll talk about the regulatory requirements, the HHS report and repayment rule, and the self-disclosure protocols for STARK and the OIG. That is it. If you want more information, again, bottom line is make sure that you remember your state laws also. I've covered mainly the federal laws, but there may be state laws that apply to you. If you want more information, the OIG is a great source. They've got their compliance resource portal that has a lot of information, advisory opinions, and guidance for you. In addition, we have a lot of information on our website that's free you can access that deals with all these statutes and most of the compensation arrangements we talked about today. That is it. If you have questions, go ahead, send them to me via the chat line or send them to me via email, and I'd be happy to respond when I can. Thank you for your participation, as always.